This demonstrated, on the one hand, the frustration that parties have in trying to get answers to financial questions of the kind that this raised. Where is the money? We're talking about events in 2007. We finally vindicated the positions in respect to the contempt in 2015, through a period of time when judges were not inclined to listen to a party in contempt. Each of us had the same sense of alarm that a consent order could be used in this way.
One Great Case, a podcast about law to learn more about people. I'm your host, Areta Lloyd.
The case that you suggested we discuss is Chiang and Chiang, and the particular decision we're discussing is the one that was rendered by the Court of Appeal for Ontario in 2009. And I read the decision, and this case, like so many others, started because someone owed someone else some money, and the creditor sued in California, as I understand it, got judgments there against your client Jay Chiang and Jay Chiang's brother. And when the creditors got a judgment in Ontario enforcing the California orders, this case took some interesting twists and turns. And there is, Justice Laskin had a great opening sentence. And he wrote, quote, "This is one of the worst cases of civil contempt to come before this court." Take it away, Tom. What were the facts that gave rise to this contempt motion?
This was an extraordinary case, and the facts are complicated, but in essence, as you've noted, this has its origins in a business transaction in California between Jay Chiang and his brother Julius and a man named John Hui that concerned the acquisition of computer monitors. And the essence of the dispute was that Jay Chiang was found to have, and his brother were found liable for failure really to account for computer monitor sales in this transaction in California. And as you've noted, the plaintiffs in California obtained a judgment. A company called KDS obtained a judgment in California. Julius Chiang defended himself there. Jay Chiang did not, and instead returned to Canada, where the company chased him with their default judgment. And that's what led to a long odyssey of litigation here in Canada.
What do we know about the Chiangs? Who were these defendants?
So they were Mr. and Mrs. Chiang had two sons. They were, Jay Chiang had Canadian citizenship, Taiwanese citizenship, and American citizenship. His family was based in the U.S., but he had family here in Canada also. And so he came back to Canada and started his life here with his wife, Christina, and their two sons. And he had a successful life here. One of the things that lies at the center of the court's decisions around the contempt proceedings in initially 2003, then 2005, then 2007, concerned the idea that although Jay Chiang had declared bankruptcy in 1998, in consequence of that California judgment, he and Christina still lived in a very large home. Their children attended a private school. They owned and operated expensive automobiles. And so the court and the plaintiff in that case began to ask questions about why that was. Because the trustee in bankruptcy had control over that estate, he became subjected to, and Christina Chiang became subjected to, investigations at the behest of the trustee. So what ended up happening is that the court here in Toronto made a number of orders that were found to have been breached, essentially orders that required the Chiangs to disclose the whereabouts of their assets. How were they funding the school tuition? How were they funding their lifestyle? That kind of a thing.
So, Tom, tell us a little bit about why the court was entertaining this, because I think the order of events judgment and then moving money seemed, I think, suspicious to the court.
Yes. So it's fascinating. This demonstrated, on the one hand, the frustration that parties have in trying to get answers to financial questions of the kind that this raised. Where is the money? The court eventually, in the person of Justice Jim Farley, who people will know ran the Toronto Commercial Court, Justice Farley orchestrated a settlement between the plaintiff, KDS, and I should say the trustee in bankruptcy, and Jay Chiang and Christina Chiang at the time, that was a controversial, in some respects, consent order in 2003. And it went this way. It said that the Chiangs agreed they were in contempt of 6 court orders that had previously been made along the lines that you've raised, disclosure of financial information, and so on. And in consequence of the contempt, the Chiangs were afforded the opportunity to purge their contempt by answering 17 undertakings, all aimed at disclosing the whereabouts of their assets. And those undertakings became very controversial in the court proceedings that followed for the next 10 years, because the question became, have the Chiangs provided sufficient information to answer the undertakings, or have they not? And the undertakings were written in a qualitative way, provide complete disclosure of the whereabouts of everything that, these kinds of qualitative answers. It led to all kinds of debates about whether the undertakings had been answered or not. The Chiang's consent order required that if they did not answer the undertakings completely within a time, and I'll say here the time was an unrealistic time, I wasn't acting for them then, they would go to jail, they agreed, each for 7 days. And that becomes important for reasons that we'll come to.
Yeah, that consent order was really different. Let's put it that way. I've never quite seen anything like that. I've never come across that in any of my research. If I'm planning a contempt motion, just thought that was so interesting.
Yeah, I've never seen it either. I don't think there is another example of it. I think it was the product of Justice Farley's effort to try to resolve a matter. I think he believed probably that it would never come to anything, that he would be able to case manage it, and he did. He tried a second case of the Chiang's contempt in 2005. Recall the 2007 order gave them a very short time to answer these very complex undertakings. I think it was 90 days or something. So they couldn't, you would not have been able to do it in 90 days, and they couldn't. Their counsel at the time was trying his best, I think. He had no experience with contempt, and he had no experience in the kind of process that Justice Farley had designed here. But Justice Farley oversaw it and didn't put them in jail for 7 days at the end of 90 days. Instead, he worked with them and the lawyers for the trustee in bankruptcy and the creditor to try to get the answers. Well, that led to a trial in 2005 at which Justice Farley said, the Chiangs have provided some information, but they haven't provided enough. They remain in contempt and have not purged their contempt, but still didn't send them to jail. He gave them more time.
Right. And so some of that was weird too, because you needed time for the more complicated undertakings, right? But then there was also this sort of, I guess, as you say, qualitative aspect to it, which is, did they make best efforts? They have to somehow compel their family. That would seem to me at the outset quite difficult to do, even though we know that they did send the money to their family.
So you're right about this. This was, among other things, something that I thought was deeply problematic about the consent order. But of course, it was a consent order, and the cases are clear that a consent order is like a contract, and you can only amend it on the same basis or avoid it on the same basis that you could set aside a contract. Now, ultimately, that became very important and a key part of the argument that we had on the appeal, as we'll come to. But I felt when I looked at it that the Chiangs were in an impossible position, and their counsel had been put in an impossible position. The court didn't want to have a long contempt trial in 2003. It was trying to find a solution, and this looked like a solution. Let's just agree you're in contempt of these 6 court orders, but let's find a way to manage the outcome so that no one is unduly harmed and the correct information goes over to the creditor and the trustee. But as you've pointed out, it required the cooperation of parties who were in another jurisdiction. Even though they were family members, they were not willing to cooperate to provide details of their assets. Eventually, I had to bring proceedings in California to enforce those undertakings, and even that was considered not to be sufficient to satisfy these undertakings. As we'll come to, that eventually became important in another context.
Good. So we mentioned about when you came in, there was somebody else who was representing them for quite some time. And tell me when you were brought into the case.
Such a good story in itself. I was trying a case in Welland, Ontario in February 2007. And on, I think, the first day of that trial, which was the first day of the Chiang's 2007 contempt trial. So after 2005, as I mentioned, Justice Farley tried the case. He then left the court, and Justice Joan Lax took over the Chiang matter. And the first order of business was that the trustee and creditor KDS said the Chiangs remain in contempt, and they wanted the matter brought back to court. Justice Lax obliged and held a contempt trial that commenced, I think, the second week of February 2007. So on the day that the Chiangs started their trial, I started a case out of town. And that evening, I was at the grocery store buying provisions because I was going to be there for several weeks. And my phone rang, and it was the lawyer for the Chiangs, a fellow named Enzo Diorio, a great lawyer who's now the chair of the Miller Thompson firm. And Enzo he obtained my name from a mutual lawyer friend and wanted some advice about contempt trials and could I help him? And I listened to his story, and I told him I would help him, but that I was currently in this case, so we would need to have an adjournment of the Chiang's contempt trial. I invited one of my colleagues, a lawyer named Marguerite Ethier, to attend with him the next day to seek an adjournment on that basis. Unfortunately, the adjournment was denied. Justice Lax said, I'd like to have your help, but no, I'm not adjourning the trial. And she declined to adjourn the case, which meant it carried on with Enzo Diorio acting for the Chiangs. We provided a little advice along the way as much as we could, but I was otherwise in the case in Welland. And so at the end of the trial, Justice Lax reserved and released her judgment, I want to say, I think in April 2007, finding the Chiangs remained in contempt and putting them over for sentencing in May. And because I was finished the other case, I came on to help them in May at the time of the sentencing. So that was my first real appearance on their behalf when Justice Lax imposed her sentence.
So hard to come in on a case, when it's been going on for so long.
Yeah, it is. It was a great privilege to be able to work with Enzo, who was totally committed to the Chiangs. He had been around this case from, before 2003 in trying to navigate what was an extremely difficult problem. And it was a case in which, if you look at the court orders, I've never had an experience like this. I've never had a case in which so many orders have been made by the court. We're talking about events in 2007. We finally vindicated the positions in respect to the contempt in 2015. It was an unbelievable odyssey. And Enzo Diorio worked very hard for them through a period of time when judges were not inclined to listen to a party in contempt. As you know, a party in contempt needs leave even to move to seek remedies in some cases. And one of the things that was put against the Chiangs in the 2008 appeal, to which you've referred, was that we were in contempt and the court should decline to hear the appeal. And there is a very interesting passage in the judgment about why the court exercised its discretion to hear the appeal, and then eventually, of course, allowed the sentence appeal, but none of the other parts.
Right, exactly. I mean, so, but before we get to that, let's talk a little bit about you come onto this case, and what were your thoughts about it at that time? And what were you, what did you specifically think was, I guess, unfair about these orders, and what was going to be your strategy?
So I had the same reaction that you had to the consent order. The whole of it just struck me as being unfair. The language of the undertakings struck me as unfair and almost impossible to satisfy, because it required that the trustee and the creditor be satisfied. The idea that a third party held the keys to unlock the contemnor's cell struck me as unfair and unworkable. The other feature of it was that I had the sense that the creditor, bringing this claim as it had on the basis of a kind of an opaque judgment and claim in California, had probably itself not made disclosure of all of the material facts they needed to have disclosed in order to obtain ex parte orders against the Chiangs. Anton Pillar orders, lay and breve injunction orders had been made. And as you know, those require disclosure of all of the material facts that the plaintiff is aware of, et cetera. And I had the sense that they had not made that disclosure, and we began to make demands for disclosure. Those demands eventually paid dividends, but many years later. And so when I looked at it, I thought that there was, on the one hand, a very serious problem. The Chiangs were in a deep hole. Many orders had been made against them, and they had been again found third time in contempt, including once on their own acknowledgement or admission. And so the immediate task became to try to sort out the sentencing. I was aware from the reasons that Justice Lax issued in 2007 that she was displeased with their disobedience of their disobedience and their flagrant breach of court orders. She was very keen to hear arguments about whether she was bound by the 7-day consent order sentence. I'll come to that. But my impression was that we were in a deep hole, and the only way out for them was to methodically, one step at a time, one problem at a time, address the issues. What's first? The sentencing. But what's the second thing was answer the undertakings. The path out of the contempt finding in the short term was to try to provide evidence, proof that disclosure had been made that was adequate. Of course, Enzo Diorio had been unsuccessful in persuading Justice Lax that that was the case. She found some information had been provided, but like Justice Farley, she did not find enough had been provided. And so that turns our attention to California and the cooperation that we were trying to gain from his relatives. They had no interest in exposing themselves to proceedings here in Canada. So that became very difficult. And eventually, as I said, we had to start a proceeding in California to try to enforce Jay Chiang's rights against his own siblings. But to get to that, Justice Lax imposed a sentence of 12 months incarceration on Jay Chiang, 8 months on Christina Chiang, to be served consecutively. So on the day of the sentencing, aware that I felt there was a good appeal and aware that we needed to likely seek bail pending appeal. We had lined up. We had arranged for a bail pending appeal application or a stay to be brought at Osgoode Hall, and we went immediately from 361 University Avenue to Osgoode, where Justice Jurians agreed to release Jay Chiang pending appeal. But he only released him for a few days because counsel for KDS and the trustee said they were not ready to argue the bail hearing. When it returned, the Justice Jurians was not sitting. Justice David Doherty was sitting, and Justice Doherty disagreed that Jay Chiang should be released pending the appeal and left him in custody. Eventually, Jay Chiang served, I want to say, something like 50 days in custody on what eventually the Court of Appeal agreed was a 7-day sentence. So it was we were unable to have him released. I want to, this is a lot, but let me add one thing. I've never seen this happen either. Mr. Chiang got parole along the way. I tried and failed to get him out of jail between the date of his sentence and the date of his release. But in the meantime, the parole system kicked in and he was granted parole. When KDS and I alerted, of course, I alerted the court and the KDS and the trustee to the change in circumstance and said, Mr. Chiang has been released. They brought an application before Justice Lax to have Jay Chiang incarcerated again on the basis that he should not be eligible to have parole as a party sentenced on a contempt hearing. The warrant of committal did not provide that Jay Chiang's sentence should not be subject to remission, parole of any kind. And so I explained to Justice Lax, or argued before Justice Lax, that her warrant of committal stood. She was functus, she couldn't amend it, and she had no jurisdiction to challenge the decision of the parole board. That jurisdiction would only lie in the divisional court. Justice Lax released a decision that did two things. Sitting as a divisional court judge, she quashed the parole board's decision and returned Jay Chiang to jail. And second, she amended her warrant of committal to provide that term that I mentioned was absent, which was that his sentence should be served without remission. And so he was returned to custody and served an additional period of time. I'm not going to be able to remember the days, I'd have to count them, but an additional period of time in custody before finally he was released on a temporary absence program that was not offside the warrant of committal. And eventually, of course, as we know, the sentence was reduced to 7 days, so that all that time was spent on a 7-day sentence. 2 weeks of which was at the Don Jail, which in 2007 was
horrific.
Was up and running. Yeah, yeah, and of course, it was quite a hardship. I felt for him. Christina Chiang eventually did serve her 7-day sentence, but that was much afterwards. Long after, because Justice Morocco then tried another contempt hearing, concluded that the Chiangs remained in contempt, but found no additional sentence was required because, of course, those orders eventually got set aside, as we may come to.
Yeah. And so before we get to that, though, how hard is it to manage your client at that point? Because I imagine it's at this point, he's feeling like the system is a little bit against him, irrespective of the facts that were found and the way that a lot of the reasons were written quite negatively against him. I can't imagine what that feels like to a client. Not great. And then he's in jail, and then he gets out and then he goes back to jail. So how are you managing?
It was very hard. I mentioned that he and Christina Chiang had two at the time, young sons. It was very traumatic for the family. Their conduct was egregious in the sense that they had breached court orders. They had not complied with the court orders, and we were never able to set those to prove otherwise. We could never prove adequately that there had been compliance. The only thing we were able to eventually do is discharge his contempt hearing proceeding. But in those dark days, when I saw him in the cells or in the Don jail, or he served part of his time at Mimico, it was very hard. It was very, very hard for them. Very hard to keep their spirits up, to be able to convey to them that we were going to change the narrative. We were going to be able to get through this, and that they would be free of these problems. I did not know at the time that it would take almost another 10 years. But it was, you're right, it was very hard when you are the only person who will or does stand up for a client in that situation. You take on a really important part of their lives and their hope. Add to that for long periods of time we were unable to be paid because the court restricted, for a time, restricted access that the Chiangs had to funds to pay their legal fees. That's itself a whole subset of court orders, dozens of court orders that were made in this case.
Yeah, I read that. It's not easy because you do have to be paid as a lawyer. It's a bit hard to keep a case going for years.
It was really hard. Justice Doherty helped in that respect with orders, and Justice Morocco did too. Relieving us of the requirement that we establish who it was who was paying for the Chiang's legal fees at a time when they were able to find support from others. The suspicion was, of course, it was Jay Chiang's funds. And eventually, in a remarkable twist in the case, KDS and the trustee established that, or found $10 million in an investment account in California, held by a company called Winner International, I think it was called. And they alleged that those funds were Jay Chiang's. Justice Morocco eventually found that those funds were jointly owned by Jay Chiang and a woman named Wang Mei, who was trading those funds. That's a whole other subset of issues that were tried in Justice Morocco's fraudulent conveyance action.
Wow.
And they found that information by piecing together documents that had been shredded and recovered from the Chiang's garbage can in a kind of a private investigation. It was quite fascinating. They took months to piece together shredded documents, found a small snippet of paper that referred to this company called Winner and referred to a trading account number, and then eventually traced that, obtained ex parte orders in California and in Ontario, freezing those funds.
Incredible. So shall we go back to the decision and
yeah, sure.
Talk about, the first thing is you had to get over the threshold, right? So you had to get the court to agree with you to even hear the appeal.
Yes. Yeah. And the court did. And this case remains a leading case. It's been cited hundreds of times for a number of different propositions. That is one of them. That a contemnor, until he or she purges their contempt, cannot have an audience in the court. In this case, there were real and substantial issues that were raised by the appeal, and that persuaded the court that in the interest of justice, the court should hear it in its discretion.
Yes, I read that. And I think I'm at the point, yes. So first they said it's an important issue. I guess more importantly, their liberty interests were at stake. And they wanted to bring a measure of certainty to these crazy proceedings.
Yeah, it was a sprawling. By that time, it was a sprawling proceeding, and it just continued. This case was important to try to, as courts decided to bring some clarity, most notably to reestablish the power or the force rather of that consent order.
Uh-huh. So great. Now you're over the threshold, and you did argue a couple of different issues, and I'll let you speak to them as you wish. The one I thought that was really interesting was, and I hope I'm not wrong here, but that you should be able to bring fresh evidence that best efforts had been made to purge their contempt. And then, of course, the other one is that whether Justice Lax made an error, a reviewable error in changing the sentence.
Yes, and just dealing with that second one first, we were unsuccessful. You will have seen that Attorney General Ontario weighed in on that question, on the authority of on the issue of the warrant of committal and the parole board questions, and we were unable to persuade the court that Justice Lax was functus when she changed the warrant of committal. The court allowed that amendment, and the court allowed the parole board's order to be quashed, and agreed that a contemnor is not eligible for traditional parole if the court orders that is so. And there's an interesting aspect of it. These are coercive sentences. Here we have a person who has not provided financial disclosure. Well, the idea is that they can go to jail until they provide it, including without parole. And yes, we were also unable to persuade the court that Justice Lax had erred in her interpretation of those undertakings, that they had to be read in a particular way, so that some of these discretionary elements were I feel still that court order should be read in this context strictly if someone is going to jail for it. But we were unable to persuade the court that there was an error by Justice Lax in the treatment of that issue. And that meant, of course, that after the appeal, it would just be more of the same kind of process. And it was snakes and ladders.
Yeah, it's interesting. So let's talk about the one point that you did win on.
Yes, it was the sentencing. Yeah, the sentence. It was agreed the court agreed with us that a consent order is in the nature of a contract, and that Justice Lax was not free to jump that sentence. As upset as she was about what she found were the Chiang's breaches of those court orders, she was bound to the 7 days. And you will have seen that the court adds that the Chiang's should not take this as any kind of victory. Such was the court's displeasure. Don't think that you've won anything, because now that this 7-day sentence is served, you can be sentenced to longer periods of incarceration if you continue to fail to comply. And that is what led KDS and the trustee to continue the campaign to enforce these judgments afterwards. The other feature of that you might have seen that continues to be relevant is what is the limit of a trustee in bankruptcy's ability to continue to question a witness like Jay Chiang, a bankrupt, or a person associated with him in the case of Christina Chiang? And the answer is essentially there is a limit, but it has to be at the level of abuse. And the court was not prepared to say that the trustee had engaged in a campaign that was abusive in its insistence that Jay Chiang be subjected to continued examinations. I've never seen a bankruptcy proceeding with this many examinations under the broad powers the trustees have. This case was cited in a case I have that is that has an aspect just this past year, past year, 2025, that concerned an Australian proceeding. This case was a feature in that judgment. It remains a relevant authority on a number of different aspects of bankruptcy and contempt practice. So, yeah, that was another feature that we were unsuccessful in reversing. At the time, that panel of the Court of Appeal did not know what a panel learned in 2015, which was that KDS and the trustee had failed to make disclosure of material facts, and that what lay behind that California judgment was a great deal more complicated than had been told to the Ontario court, and that KDS had itself engaged in a kind of fraud. It was a remarkable change in the perspective. So it came back to the Court of Appeal on an important question that concerned whether J. Chiang could be discharged from bankruptcy because the judgment in California concerned a breach of fiduciary duty. And the question, as a matter of first impression in the Court of Appeal in 2015 was, well, if J. Chiang owes a fiduciary duty to the company that he was part of, is that a relationship that means that his bankruptcy does not he cannot be discharged from bankruptcy because it survives? And the answer of the Court of Appeal was no. He's entitled to a discharge on that basis.
Vindication at last.
At last, in part at least. I mean, he was still on the wrong end of a number of court orders that were never set aside, and he was found by Justice Morocco to remain in contempt. But Justice Morocco did not impose any additional terms. He discharged him from bankruptcy. His various passports were ordered to be returned to him, and he was essentially free of these proceedings.
And that was 10 years after this?
That was certainly, yes, by 2015. So if one imagines that he entered bankruptcy in 1998, that's the total length of time. And longer than that if you imagine the California proceeding. But he declared bankruptcy, or made an assignment in bankruptcy rather, in 1998. Contempt proceedings in 2003, 2005, 2007. Again in 2000, I think in 11, with Justice Morocco. A 50-day trial on that issue and the fraudulent conveyance action that KDS brought to chase the proceeds of this judgment, and against all of the relatives, each of whom was found not to have participated with him in the defendants in that action were found not to have participated with him in any kind of fraudulent conveyance. He was himself found liable for all kinds of financial misdeeds, though, in that judgment by Justice Morocco. I mentioned the Winner International money that was divided between the trustee and Mei Wang. A fascinating twist and a form of conclusion to the story.
Yeah, it's I think there's a couple of lessons here for all of us. So we always talk about crafting orders with being very specific and intentional, I suppose, is the word. And wow, this case really makes you scared about it. Like just I better think about all the things that could possibly happen.
It's so true. I agree with that. I think this was a real lesson for me and all of the others. Dozens and dozens of people worked on that matter in our firm between the time it started in 2007. I think officially it started about 3 days after that first call in February 2007, when we came on to help Enzo Diorio. And until the end, dozens of people worked on it. And I think each of us had the same sense of alarm that a consent order could be used in this way. I think it was. I think it was the product of commercial court practice. I think Justice Farley had a particular vision for this case. He was going to see to it that it didn't occupy a long period of time when it was obvious on the one hand that the Chiangs were in breach of these 6 orders. They were pretty plain orders themselves. There was nothing unorthodox about those. But they were rolled up into this consent order that said, yes, I admit I'm in contempt of these orders. Now, therefore, I will purge my contempt by answering these undertakings. But that's when the force of that court order became quite problematic, because it was not capable of a single interpretation. And it's not a satisfactory outcome. I think it satisfied, on the one hand, the trustees' stated wish to, and the creditors' stated wish to have the information that was required to be produced by the court orders. Some of those orders had been spent. The contempt, there was no actual purging that was required of orders that had come and gone. But the consent order breathes new life into them, with the answer to the requirement that answers be given to undertakings. At the time that this was playing out, there was a case going on in the U.S. that you may remember. I think the trainer of a baseball player, I think it was Barry Bonds, but a baseball player in the U.S. who was implicated in the taking of performance-enhancing substances, was required to come to court and reveal what he knew about the situation. He declined to speak. And so the court gave him a period of incarceration until he was willing to provide his testimony. And so there you have a circumstance in which a coercive court order is used to try to require a witness to cooperate. And that person could theoretically be in custody for a very long time, but they, as the expression goes, hold the keys to their cell. They can choose to be released from jail by coming to court and testifying honestly. Here, the keys to the cell were held by the trustee and by the creditor, and I suppose by Jay Chiang's relatives in California, who simply would not cooperate. And they wouldn't cooperate to the extent that was required by the creditor and the trustee in the court order. And as I mentioned earlier, even when we obtained orders in California requiring them to cooperate, they declined to cooperate. So now we have a court in California. What are we to do next? Seek a contempt order against this person's relatives in California? It wouldn't survive. It wouldn't provide any satisfactory answer to the court. But I felt we had gone as far as we could to say, surely now we have complied with this undertaking. We can do no more than that. But what lay behind all of it was a sense that Jay Chiang's relatives and others were covering up for him, that this telecom business that had been established as something he was working on as a person in bankruptcy had not truly been disclosed, and that he had assets somewhere. And in that sense, I suppose the case was a conventional case of a creditor chasing a debtor who has assets they have not accounted for.
Mm-hmm. So what's your takeaway, I guess, about human nature when you look at this case?
Yeah, so I think I've learned a number of lessons through this. One was a reminder about how complex problems like this have to be solved one step at a time. Uh, well, I like to say when choosing between bad and worse, always choose bad. There were no good outcomes that we could see in the near term. This was going to always be a long-term solution. And so we had to try to find the things that needed to be done that day. What next? What is the next play and the play after that? And so it was a good lesson in perseverance. And that was also important, as you mentioned, in terms of the client, trying to keep the spirits of the client up, trying to have him feel hopeful. I should have mentioned, I did send Christina Chiang out after the sentencing to a team at Weir Folds led by David Wingfield, who did a superb job with Hillary Book on behalf of Christina Chiang. And so I had someone to collaborate with that was important too, to shoulder some of the responsibility. But it was important also for my colleagues that I could try to provide them with a reason to be optimistic, that there was going to be a day when we would see a positive outcome, one step at a time. The other thing I think you've raised this too, the other thing that became important was to try to be very disciplined about those court orders and the steps that we were going to take. We needed to not put a foot wrong, and to try always to protect the rights that Jay Chiang and Christina Chiang still had as contemnors, by making certain that there was discipline brought to that process to insist that their rights be respected wherever we could. This became a real issue in terms of these examinations. We had no success in curtailing the examination of Jay Chiang continuously under the powers that the trustee had. But it became important to try to focus on that in a disciplined way.
Yeah, I think that's great advice to any lawyer who has a strong belief about a case and a strong feeling and knows that, perhaps the digging hasn't even begun and that has to happen, but sees a Sisyphean task ahead, which this obviously was.
It really was. It's discouraging to be able to, or be unable, frankly, to be able to change the trajectory of a case with order after order piling up, knowing that you might have the sense, and we did have the sense, that this outcome would be changed, starting with that sentence issue, and then building on that to be able to show, wait a minute, we have a case. We can shine a light on the conduct that KDS had, and with the company that lay behind that, the Coe brothers. You will have seen reference to this. We had a sense of confidence that there was more to the story, that the trustee had not been told everything, and eventually, of course, we were able to successfully have a different lawyer appointed for the trustee to get the trustee independent advice, and that led to a change. But between those two times, we were faced with failure after failure. We were unable to change these outcomes, especially around some of those live issues on the appeal about parole for contemnors, about changing a warrant of committal, those sorts of, or the undertakings, as we've spoken about. It was, we faced a lot of losses that felt at the time insurmountable.
Yeah, nobody likes to lose. How did you feel, Tom, when you read the first sentence of that judgment from the Court of Appeal? Is there's always some trepidation when you open a decision?
Yeah, I mean, and recall that reserve in that court was almost a year. They were out a very long time. And the judgment is really a beautiful piece of writing. It's a tremendous judgment that has had it had a real impact. It is referred to in so many cases of contempt, or in respect of all of the other issues that were raised. It was disheartening because although gratifying that the sentence had been reduced, it didn't feel great that Mr. Chiang had done the 50 days plus in jail, and that we could not change the outcome over those undertakings. I really was hopeful that the Court of Appeal would bring an end to what looked like quite an unsatisfactory process around those undertakings. But instead, we found ourselves back in Justice Lax's courtroom afterwards. And you will have seen also that I invited the court to send the matter back to a different judge if it was going back to the Superior Court, because Justice Lax had made such strong findings against the Chiangs. I felt it was right that a different judge should take the matter. The Court of Appeal disagreed and said if Justice Lax is not going to carry on, it's going to be Justice Lax's decision. And to her credit, she heard us out on that issue and agreed that it would be better if a different judge heard the next part of the proceeding, and enter Justice Frank Morocco, who took over from there and tried those other cases, as I've mentioned. I think that was a very courageous decision by Justice Lax, because I think the trustee and the creditor were keen to have her stay.
Only somebody with your finesse could convince a judge to assign a case to another judge.
Well, what we were able to say to her is it will lead to a recusal motion invariably, because, and you're probably familiar with these cases, there are some cases that say that where, in circumstances, especially contempt, where a judge has made strong credibility findings, well, they should, for the appearance of justice, if nothing else, yield to someone else on a further proceeding in the nature of contempt over that same contemnor. But of course, the Court of Appeal disagreed and said it will be Justice Lax's decision if she wishes to carry on. And I was very pleased that it didn't come to that she saw the wisdom in letting this go. Her decision is also very well written, and you will probably remember the first paragraphs of her first paragraph of her decision is very powerful too. She refers to the fact that Jay and Christina Chiang live in a 10,000 square foot house. He has no employment. They drive expensive cars. Their children are at an expensive private school, and yet they're in bankruptcy. It was a very powerful piece of judicial writing also.
Yes, it was. She certainly painted a picture.
Yeah. And not a pretty one, unfortunately.
I really appreciate you talking about this massive case and bringing it down to its essence. I thought there were a lot of really interesting points that you made, and I really appreciate your time.
Well, I'm so glad to be here, and thank you for including me. I will look forward to watching your future podcasts. Thank you.